This is a very important hearing, Mr. President, or Mr. Chairman. There's a lot of issues to bring up. However, over the time that the Attorney General was last here, I've concentrated my oversight on Operation Fast and Furious. Just over 9 months ago, Attorney General Holder sat in my office and I handed him 2 letters. I had written to Acting Director Kenneth Melson of ATF. My letter mentioned 1, the death of Border Patrol Agent Terry, 2, the allegations that ATF had sanctioned the sale of hundreds of assault weapons to straw buyers, 3, the allegations of 2 of those weapons had been found at the scene of Agent Terry's death, and 4, the allegations that the whistleblower who provided this information were already facing retaliation from the agency. Just 4 days later, the reply from the department explicitly stated that the whistleblower allegations were false. It also claimed that, quote, ATF makes every effort to interdict weapons that have been purchased illegally and prevent their transportation to Mexico, end of quote. In the 9 months since then, mounting evidence has put the lie to that claim. Documents contradicting the department's denials came to light. Then 6 ATF agents testified powerfully at 2 House oversight hearings. They also confirmed that gun walking occurred in Operation Fast and Furious. Just last week, Assistant Attorney General Lanny Breuer admitted in this room that the department's letters to me in February was absolutely false. But it gets worse. Mr. Breuer also admitted that he knew all along it was false. He could not recall whether he helped edit it. However, he knew it was false because he was aware of previous gun walking operations called wide receiver. Yet he remained silent for 9 months. He was aware that Congress had been misled, yet made no effort to correct the department's official denial. Much has been said recently about guns being walked in Operation Wide Receiver during the Bush era. It doesn't matter for me when it happened. We need answers. Bush-era prosecutors refused to bring the case. However, under Mr. Brewer's leadership, headquarters revived it, despite the gun-walking issues. It was Mr. Brewer's responsibility to clearly communicate that gun walking was unacceptable and to institute oversight and safeguards to ensure that it did not happen again. He did not do that. Mr. Brewer admitted before this committee last week that one of his deputies informed him of gun walking in Wide Receiver, April 2010. He also admitted that the same deputy approved at least one of the wiretap applications in Operation Fast and Furious. In order to justify tapping the phone of a private citizen, the law requires that agencies show they have tried everything else first. But the very same facts that would show the need to obtain the wiretap would also show that the department knew these individuals were trafficking in weapons. The government should have stopped the flow of guns to these criminals. Anyone reviewing the wiretap affidavits would probably know that was not happening. I would also add that this tragedy should not be used to call for new gun control. The straw buyers in Fast and Furious were already breaking the law. They should have been interdicted and arrested nearly a year earlier than they were. The faulty statistics cited by some about U.S. guns in Mexico include U.S. weapons sold to foreign militaries, weapons that were transferred into Mexico years ago, guns from Fast and Furious, stolen weapons, and many other sources. As we learn more about the utter failure to enforce our existing gun laws in Fast and Furious, I'm eager to hear from the Attorney General who he plans to hold accountable. I also want to know how he plans to prevent another tragedy like this in the future. But let me be clear. The bottom line is that it doesn't matter how many laws we pass if those responsible for enforcing them refuse to do their duty, as was the case in Fast and Furious. Thank you, Mr. Chairman.
Senator Grassley.
Now, I was going to start with those letters that you just referred to that I gave you on January 31st, so I won't, you've introduced my question, so I'll go immediately to the question. When we met that day, did you know that the guns connected to an ATF operation had been found at the Terry murder scene?
I did not.
Thank you. Less than 48 hours after Agent Terry died, your deputy was informed that guns found at the Terry scene traced back to Fast and Furious. We have emails and detailed briefing papers that went to Grindler on December the 17th. Did Mr. Grindler ever say anything to you in December or January about the connection between the ATF and the guns found at Terry's murder scene?
No, he did not, but I think it's understandable in the sense that the information that was shared with him did not indicate that any of the tactics that we find in the flawed Operation Fast and Furious operation were actually mentioned in the email that you referenced. So he did not share that information with me.
Okay. Documents produced by the department suggest that your deputy chief of staff spoke with U.S. Attorney Dennis Burke about Fast and Furious shortly after Agent Terry's death. Did Mr. Wilkinson say anything to you about the connection between Agent Terry's death and the ATF operation?
No, he did not. The conversations that they had were about a variety of things as I've looked at the emails now. The possibility of me coming out to, at some point, talk about, engage in a press conference, other matters, but there was no discussion between them of the tactics that are of concern with regard to Fast and Furious. And as a result of that, Mr. Wilkinson did not share information with me about his contacts with former U.S. Attorney Burke.
Last week, the head of a criminal division, Lanny Brewer, said that he deeply regrets his failure to tell you earlier about gunwalking in Operation Wide Receiver. But what about his failure to tell Congress and correct false statements in the department's letter to me on February the 4th? Is that acceptable to you that he did not tell us about those false statements in the letter of February the 4th?
Well, let me clear something up. The information that was shared with you on February the 4th in that response, there was information in that letter that was inaccurate. The letter could have been better crafted. We were relying in the crafting of that letter, people were relying on information provided to them by people who were, we thought, in the best position to know what was accurate. People in the U.S. Attorney's Office, people at ATF, people who themselves have now indicated in their congressional testimony before the House that they were not aware of the tactics that were employed. As a result of that, the information that is contained in that February 4th letter to you was not, in fact, accurate, and that is regretful. I regret that.
Did he offer you his resignation because of that?
No, he has not, and I don't expect to hear a resignation offer from Mr. Brewer.
You're refusing to provide drafts of that February 4th letter and emails about the drafts, even though they have been subpoenaed by the House without a valid constitutional privilege that of course, risks contempt of Congress. Why would you risk contempt of Congress to prevent us from finding out who reviewed the drafts of that letter and whether they knew that they contained false statements?
Well, we'll certainly try to work with you in providing you all the relevant information that we can. We will, however, act in a way that's consistent with other attorneys general, have made determinations as to what information can be shared with congressional oversight committees, and these are Republican as well as Democratic attorneys general, and I will act in a manner that's consistent with the history and the tradition of the department.
If those documents show that Mr. Brewer reviewed a draft of the letter before it went out and failed to correct the statements that he knew was false, would that be a reason for his resignation?
That would be a reason for a concern, but I think the facts show that the people who were responsible for the drafting of the letter did not know at that time that the information that was contained in that letter was inaccurate. We do now know, looking back, that the information provided to you was inaccurate, and as I said, that is something that I regret.
Mr. Brewer's deputy, Jason Weinstein, was also aware that ATF walked guns. He approved the wiretap application for Fast and Furious, and he briefed Judiciary Committee staff on February the 10th in response to my letters. Did Mr. Weinstein review a draft of the February 4th letter before it was sent to me?
I don't know.
Who will be held accountable for allowing a letter to Congress with a statement that many people in the Justice Department knew was false?
Well, again, I have to dispute with due respect the assertion that people in the Justice Department knew was false. People in the Justice Department who were responsible for the creation of that letter, again, relied on information provided to them that they thought was accurate. We only know that the information was inaccurate in hindsight. At the time the letter was prepared, our best thought was that the information supplied was in fact correct.
Someone in the Justice Department leaked a document to the press along with talking points in an attempt to smear one of the AATF whistleblowers who testified before the House. This document was supposed to be so sensitive that you refused to provide it to Congress, but then someone provided it to the press. The name of the criminal suspect in the document was deleted, but the name of the ATF agent was not. This looks like a clear and intentional violation of the Privacy Act, as well as an attempt at whistleblower retaliation. In a private phone conversation with me, you already told me that someone has been held accountable for this, but your staff refused to provide my staff with any details. Who was held accountable and how?
You know, it almost pains me, and please don't take this away from Senator Grassley's time, to pain me that, as you said, we had a private conversation. You sent me a handwritten note that I took very seriously. You and I worked together on a variety of things. I think I have a good relationship with you. You sent me a handwritten note that I looked at, took seriously, referred that letter to OPR, the IG, I'm not sure which of the two, and asked them to try to find out what happened. I called you to try to indicate to you that I had taken that matter seriously, that action had been taken. You know, in a different time in Washington, I'm not sure that what you just said necessarily would have been shared with everyone here, but, you know, so be it. It's a different time, I suppose. In response to your question,
you understand that I told you over the phone conversation, if you wanted me not to ask this question, that I said, have your staff inform my staff, because I work very closely with my staff, and give the details so that I would know that this would be an inappropriate question to ask at this hearing.
We'll let the Attorney General answer, and then we'll go to Senator Cole. Keep the same rule I applied to myself.
You went 1 hour, 1 minute and 40 minutes.
No, I did not on my
questions. You asked the question, but he answered 1 minute.
I finished my questions before my time was up. Go ahead. You can answer his question, even though he asked it after his time was up.
With regard to the question, the matter is under investigation. There were a couple of leaks, and those leaks are under investigation by the Inspector General, by the Office of Professional Responsibility, and I'm not in a position to comment on ongoing investigations.
I got a couple of statements I want to make before I ask a question, and they before the Justice Department produced documents on wide receiver, my staff asked for additional information on previous cases of gun walking. However, on September 30th, the department declined to provide a briefing on such cases, so I've not limited my questions to Obama-era operations. And it's hard to get state answers, though, if you don't get these briefings. Now that the majority is interested in gun walking after 9 months, and they're in the majority, they'll probably help us get our questions answered. But that's one reason that I don't want the inference to be left that I'm only interested in overseeing Democrat presidents on gun walking. I want to speak to something Senator Schumer brought up, and I think his facts are entirely accurate, but he referred to wide receiver, where I think he was, he referred to wide receiver, but all the facts are in regard to the Hernandez case. I just want to make clear something that's been widely misunderstood. The memo to the Attorney General McCasey referred to what is known as a controlled delivery in a case called Hernandez, not gun walking. The U.S. coordinated with the Mexican law enforcement, which was supposed to be waiting on the other side of the border to interdict these weapons. And so this is a distinct from Fast and Furious and Operation Wide Receiver, in which no effort was made to work with Mexico and guns were clearly walked. First question to you. Your Justice Department stood by its February 4th denial to me even after I sent the first set of documents that showed otherwise. So question for you, General Holder. You say that you were relying on others to correct the misstatements in the February 4th letter, yet Mr. Brewer himself admitted that he first knew firsthand that those misstatements were false at the time that they were made. Shouldn't he then have notified either you and or Congress at that time?
Well, I think that's one of the things that he admitted, as I remember his testimony. He said he made a mistake in not bringing to my attention the fact of his prior knowledge. And, you know, he admits that he made a mistake in that regard.
Okay. Your deputy received a lot of details about Fast and Furious in March 2010 briefing, details that I believe should have raised red flags. For example, he was informed that just 3 straw buyers bought 670 guns. He was informed that the ATF followed them to stash houses. And he was informed that the guns ended up in Mexico. So you can look at the charts with Grindler's own handwriting on these things here. Yet you said a recent letter that Acting Deputy Attorney General Grindler was not told of the unacceptable tactics employed in the Operation Fast and Furious during that briefing. If by unacceptable tactics you mean watching straw buyers illegally buy guns without seizing them before they get to Mexico, isn't that exactly what he was told?
I don't know exactly what he was told, but as I understand what he was told is that he got this briefing as part of a monthly interaction that he had with ATF. The person who did the briefing was Ken Melson, the acting director of ATF, who at that point indicated that he did not know about these inappropriate tactics. Melson was also the person who briefed Chairman Issa, and as I understand it, gave him pretty much the same briefing. So I don't know. I'm not sure. I draw the conclusions that you do on the basis of that from what I understand about what the nature of the interaction was. One of the things that I have been told is that during the course of that briefing, the question of guns walking was not briefed to then acting Deputy Attorney General Grindler.
One of the AFT briefing papers explicitly says that the strategy was, quote, to allow the transfer of firearms to continue. And one of the emails forwarding that paper says that it is, quote, likely to go to DAG, which I assume is Deputy Attorney General, end of quote. You can't know for sure that no one informed him of that strategy, can you?
Well, as I've understood it, he was not told of the tactics, the gun-walking tactics. As I've also been told that the picture that you have up there is of guns that were recovered in the United States. This is what, again, they were delivered in the United States. This is, again, what I've been told. I'm not as intimately familiar with that interaction as perhaps you are, but what I have been told is that the fact is that acting Deputy Attorney General Grindler was not told about guns walking. He got the same briefing that Congressman Issa got from the same person, that is Ken Melson. And Ken Melson has indicated that at the time that he did that briefing, he was not aware of the gun-walking techniques. In fact, he didn't know about it, as best I can remember, I think until March of 2011 when he talks about his stomach turning.